All right, good afternoon, everybody, and welcome to today's webinar, the second webinar in our 2023 MSHA Defense Report webinar series, MSHA Basics and the Mine Act, and MSHA Inspection Powers. So welcome. We'll be taking a dive today on a bit of a remedial topic on the MSHA. Hopefully we know most of this, but it's a good refresher and a good background if you don't. My name is Nick Scala. I am the chair of the MSHA practice group over here at Con Mockdale Carey. Where we work with companies all around the country dealing with MSHA questions, representing companies in challenging MSHA citations, or just liaisoning and managing MSHA investigations, whether those are serious accident investigations, fatality investigations. Hopefully we don't have to do that for anybody on this call ever, but we are well-versed in that, unfortunately, as well as agent liability, 110 proceedings, and 105 investigations under discrimination. Here at Con Mockdale Carey, we also represent companies with OSHA nationwide and all the different state plans where you might find yourself, as well as on general labor and employment matters. So if you got questions on any of those areas, reach out to us, not just the MSHA side, but we're obviously always happy to talk about MSHA with each of you. So when we're talking about MSHA, we have to start, if we're doing a basics, a background, with the Mine Act. So what is the Mine Act? How did it come about? And what did it do? You should be aware that the Mine Act of 1977 governs MSHA, right? It doesn't necessarily govern MSHA as much as it created MSHA and is what MSHA uses to govern us, right? That is the legislation that passed from Congress that gives MSHA its authority and its power. Quick history lesson: before the Mine Act of 1977, that was not the first attempt to govern the nation's mining industry. That goes all the way back in the late 1800s when the first federal rule for mining safety came out, and it was having to do with ventilation in underground coal mines. For obvious reasons, we understand that that is an area that would garner attention early on. Ventilation has to go with mining and underground coal. A lot of that ventilation has to go with reducing the risk of explosion and catastrophic disasters there. In 1910, the Department of the Interior was tasked with governing the nation's mines, and the Bureau of Mines was created. That was the entity which really had the authority or jurisdiction over mining until we got to the Mine Act in 1977. And there was a couple of different iterations of rules that came out. For example, the Coal Mine Safety Act of 52, the Metal Non-Metal Mine Safety Act of 1966. These imposed some regulation on the industry, but it certainly did not have the teeth of what we see now. So what happened and how we get to the Mine Act of 1977? As mostly we see the case with safety and health regulation, especially on the MSHA side, the creation of developments or advancements in that are most of the time event driven. In particular here, kind of the preceding event that led to the passage of the Mine Act in 1977 was a Sunshine Mine disaster in Idaho in 1973. It was an underground silver mine, significant disaster. Many miners lost their lives. It was a terrible tragedy, and that kickstarted, or at least gave the impetus behind Congress to get this Mine Act in 1977 together. So what did that do, and how did that kind of change the landscape for us? First and foremost, it moved mine safety and health responsibility from the Department of Interior to the Department of Labor. If you don't know that, the U.S. Department of Labor is over top of MSHA. It's over top of OSHA. So, that's why the head of MSHA is called the Assistant Secretary of Mine Safety and Health, because they report to the Secretary of Labor for the Department of Labor. The Mine Act also brought coal and metal safety regulation under the same legislation. We don't have a Coal Mine Safety Act anymore or a Metal Non-Metal. It's the Mine Safety and Health. and Enforcement Act, all right, or the Federal Mine Safety and Health Act of 1977. So it brings them both under. And as we go through and read the text of the Mine Act, and you'll see this a little bit on the next slide even, we see that it really was kind of it was a Coal Mine Safety Act in the large part, with some change in language to bring metal non-metal mines underneath. And metal non-metal, that covers everything that isn't coal, whether that's precious metals, gold or copper or things of that nature, or construction sand and gravel and limestone. Everything else falls under metal non-metal. And it's interesting to see that was something that first happened back then, because we know even with MSHA, until the last couple of years, coal and metal non-metal enforcement and safety were run separately. During the last administration, the Trump administration, we went through what they were internally calling the blur, which is where they merged coal and metal non-metal divisions to create, just a unified mine safety and health enforcement group instead of a coal mine safety and health enforcement and a metal non-metal. So, that kind of started with this single legislation, run separately for a long time. A lot of factors drove to the blur, many of which were related to kind of the decrease in the coal mining industry and just the presence, and then merging those together to kind of what MSHA touted at the time with the help of run on a more efficient footing. We don't hear a lot about the blur these days, but the effects of it are still in place in terms of, responsibility of mines and the kind of the grouping and the rationing of resources being consolidated into a single enforcement division and hierarchy for both. Additionally, we saw the Mine Act create mandatory training requirements. That was a new requirement when we saw in federal regulation. It gave MSHA the ability to pursue criminal and or civil liability against individual agents of management. That's an area that we always want to be aware of, especially on the criminal side. MSHA does have that power. It is not utilized very often, but it is utilized. Typically, when we see criminal liability with MSHA, it is having to do with attempting to defraud MSHA, whether by, an example would be creating false training records or falsifying training records, or a recent case where there's been criminal prosecutions is a mine was essentially falsifying their air sampling records by running the samples above ground when it was underground coal mine in an office, as opposed to on the actual miners in the underground. So, use our best judgment. Let's not try to lie to MSHA or defraud MSHA in any way, and we're probably not going to have to worry about the criminal liability side of this. Civilly, that means that just they have the ability to pursue and assess individual penalties against individual agents of management. They aren't common. That is much more common than the criminal side. It's still not a common occurrence. But, in the event that we see an unwarrantable failure issued, we should be prepared that MSHA could launch a civil liability investigation. They're called a 110, and we'll talk about those later a couple different times. But, just be aware that is a power that MSHA has. That comes from the Mine Act. The Mine Act of 1977 also created the Federal Mine Safety and Health Review Commission. That is the independent organization which hears contest and litigation of MSHA citations before we get to the federal court system. There is a similar system in place for OSHA contests called the Occupational Safety and Health Review Commission. It is not part of MSHA. They are distinct, but it was created by the Mine Act as a venue for operators in MSHA to have their initial round of litigation. And then lastly, the Mine Act of 1977 created MSHA. It created the Mine Safety and Health Administration and then bestowed upon it these powers to go in and enforce these mine safety and health regulations. So walking back, it was a pretty, in our world of mine safety and health, and particularly dealing with MSHA, it is the source of that authority. that agency and, still governs it to this day. There's been really just one more major legislation on mine safety and health which has been put in as, in addition to the Mine Act, and that's the Mine Act of 2006, which builds upon what was already in the Mine Act. So if you hear MSHA management or leadership talk, they will refer back to the Mine Act. This is what they're talking about. It is the source of their authority and the source of MSHA itself. So what did it do? In addition to those items, it gave MSHA jurisdiction over each coal or other mine. Remember, I know most of us on this today are in the non-metal world. So you are the or other mine, the products of which enter commerce or operations of which affect commerce, and each operator of such mine. Every miner in such mine shall be subject to the provisions of this act, right? So that is a pretty all-encompassing breadth of jurisdiction for MSHA to touch all things mining, right? And that to this day is what we, are thinking about and dealing with. And, oftentimes this question of, do your products enter commerce? Do your operations or products affect commerce? That's largely a throwaway. If we're selling material, that's kind of a throwaway analysis. You're going to affect commerce, you're going to enter commerce, but it really is saying that you have this jurisdiction that covers all things mining. So that's probably not that surprising given what we know and that what we deal with when we're working with MSHA. So the other part of that is OSHA existed at the time MSHA was created. So there is between the two, and this was signed in I think 1979 is the official date of the interagency agreement, but an interagency agreement between MSHA and OSHA on delineating jurisdiction between the two. So why are we talking about this, almost 50-year-old document right now? So it is important because this is still a document that we refer to and the agencies refer to when determining kind of those question operations. Is this mining? Is this manufacturing? And should it be regulated by OSHA or MSHA? If you have questions, is my process that I'm undergoing right now going to be considered milling or mining, which fall under MSHA, or is it not? Is it crossing that threshold into refining or manufacturing, in which OSHA has jurisdiction? This is still a central document that we look to. It not only defines, mineral milling, which it assigns to MSHA for jurisdiction, but it also lists specific types of operations that may or may not be assigned to different agencies for jurisdiction. So one common one that comes up, or one that's distinctly laid out, is gypsum board plants. If you are operating a gypsum manufacturing facility, but it is on the mine where the gypsum is extracted, MSHA has jurisdiction over it. If that gypsum plant and manufacturing facility is off the mine site, it specifically outlines that is the jurisdiction of OSHA. So a useful document if we're having these questions. It also defines what is a borrow pit. Usually a borrow pit is the area where we live in when we're talking about, is there, probably some kind of extraction of mineral resources happening, but it shouldn't be under MSHA's jurisdiction. Borrow pits have to be narrowly construed, and they are narrowly construed. There's a lot of litigation out there that focuses on it. But, one of the big questions is what processing is taking place, if any, and what is the use of the material. Borrow pits are intended to be materials extracted. It isn't processed in any way. That would put you under milling. It isn't separated or sized in any way other than to remove debris and trash with like a scalping screen. So you're just taking the material out of the ground and using it for what the language in the act or in the agreement says. It is bulk intrinsic qualities. So are you using it for filter, et cetera? To the extent you are going to be having a portable plant up there and you're crushing or you're separating and sizing, you're going to fall under MSHA's jurisdiction. And we had a jurisdiction webinar scheduled for later in this year where we'll dive into that quite a bit more, and the interagency agreement quite a bit more. But just an area where we need to be aware of outlining jurisdiction over operations. I will say, if you have questions about who should be over what area of your operation, don't wait to be enforced. Try and sort that out early on. There are operations and facilities that are a single continuous geographic area, but there's co-jurisdiction on site. MSHA has jurisdiction over some of it. OSHA has jurisdiction over some of it. You have to, though, go to the agencies and define why you think that should be the case. And you have to explain where this kind of transition from mining to manufacturing occurs. So a very interesting topic. I, enjoy talking about jurisdictional distinctions between MSHA and OSHA. Maybe I'm unique in that, but we'll dig into that more later this year on our webinar specifically on jurisdiction. Additionally, with the Mine Act, we MSHA got the ability to assess penalties, right? That is the fines that come with citations that are issued to a company when we see, whether or not that is a penalty for a 104A or a penalty for a 104D. That's obviously going to affect the size of the penalty. But, MSHA does have that authority from the Mine Act. They're supposed to go through normal assessments unless MSHA has designated something for special assessment. And we'll talk about that in a couple of slides, but it's supposed to be looking at the criteria of the appropriateness of the penalty, the history of your prior violations, if any, how were you negligent, the gravity of the violation, and good faith of rapid compliance. And then finally, the effect of the penalty on the operator's ability to continue business. So some areas that it looks at, these are also the areas, if you're challenging a citation, that the judge is supposed to look at when determining what penalty it will be changed to. So, it's certainly an area where there should be structure to it, and there is structure to it. In fact, MSHA has in their 30 CFR, it's part 100.3, a scale that is a 208-point scale for assessing penalties. The way we get points is each designation on a citation has a point value. So if MSHA designates a citation as unlikely to occur, that is going to have less points as if they designate it as reasonably likely to occur. Essentially, kind of an easy way to look at it is the farther a check mark gets to the right of the page, the more penalty points that check mark is worth. So unlikely, fewer points than reasonably likely, fewer points than higher likely, fewer points than occurred, if you're familiar with the likelihood designations of gravity. So that's important, though, because MSHA goes through, they add up all your points for the designations. They look at your enforcement history and see how many citations you've had per inspection day, or how many violations per inspection day you have on a particular standard. Those can all add points to it. And then they go to this chart. As I said, it's a 208-point scale, but really it lives between an 80-point area. And that's because 60 points or fewer, you're at the statutory minimum penalty, which is $159 right now. 140 points or more, you're at the statutory maximum of regular assessment, and that's $85,580 for a penalty. In between, it's a logarithmic scale, and that just means the higher you go, the faster the penalty increases. So you don't have that the penalty jumps by 10 points between each point. It increases more quickly as you get higher. So you have a 159-point penalty, 30 points higher, and you're at 90 points from that minimum penalty, and you're at a $1,700 citation. 30 points more, you're at a $20,000. And then 20 points after that, you're already at 85. So it moves quickly. And that's in part because, one designation change can really jump up. So if you go from moderate negligence to high negligence, that, depending on the rest of the classifications in the citation, might be a $20,000 jump, or it could be you know, a $200 jump based off of the rest of the designations if you're looking at that 60 points or fewer. So it's important to evaluate that, especially if you're contesting and you're trying to think about, why am I contesting it? What's an easy venue or an easy reason to justify that? If you have the penalty, especially high dollar penalty citations, getting some small modifications that might not even be throwing out the citation or having it withdrawn have the potential to be pretty impactful on your penalty. So your total penalty. So I would pay attention to that. I do see we have a question in. I'm going to just address that here after another slide. So the special assessment side, this is when MSHA goes in and says, we think the penalty should be evaluated to be higher than what the point total says it is. And usually that's because there's been a serious injury or maybe a fatality or some other kind of egregious circumstances that MSHA wants to evaluate whether or not they essentially add points to that calculation. They still use that 208-point scale to come to the penalty, but what they'll do is they'll go in and review it and say, well, we think that this negligence, you know, while being high and not being reckless disregard, we think there should still be an extra 20 points on negligence, and that increases the penalty. We haven't seen that a lot, honestly, since the Joe Maine administration, where it happened with increasing frequency, but it still exists. And, you know, I think we probably I'm starting to hear more about it, especially with, you know, some serious accident or citations related to that or fatalities. They're telling MSHA, saying, well, we have to evaluate it for special assessment. So, you know, keep that in mind. It's still not going to go above that 85,000 even if it is specially assessed, unless it qualifies as a flagrant. But being special assessed doesn't mean that. Usually, if you're doing special assessment because they're trying to get a higher penalty and it doesn't qualify as a flagrant. If we see down at the bottom of the screen, if you are at a flagrant violation, it can go all the way up to $313,000, almost $314,000 per issuance. Flagrants aren't issued often, usually a handful of them a year, but that is MSHA's most aggressive penalty that they can rely on and go into. The other areas where we see penalties have been assessed is, you know, C, if there is someone who doesn't abate something in the timely fashion, that we call that like a 104B order, if you're familiar, or failure to abate. Those usually are not assessed, but MSHA has the ability to assess them at almost 10,000 a day, just shy of that 9,271. There's also a standard in here which says the minor can be cited up to $390 for willfully violating standards related to smoking or carrying smoking materials matches in an area where they're not supposed to. We don't see those often, and if we do, the company gets a citation as well, but that is specifically called out in the Mine Act for authorities there. So we did have a question. I'll jump back into it because it's a jurisdiction question. So, and I think it's an important one that we need to talk about. It essentially says, with new construction on a mine site, who has jurisdiction, OSHA or MSHA? So construction of a mine, according to the Mine Act and according to the Memorandum of Understanding, falls under MSHA's jurisdiction if it is for development of the mining process. MSHA's opinion is that goes all the way down to clearing the land and doing, you know, lumber work. I'm not going to say I necessarily agree with it, but that's their position. So if you are an active mine site and you're building a new processing area, that's going to be under MSHA's jurisdiction. If you have a large mine site and you're building a different part of your operation, that's going to be OSHA regulated. That will fall under OSHA, but you're going to have to explain to MSHA that it is not going to be a mine site. It is not going to be part of the mining process. It is not going to be involved in the processing of mineral milling. That should fall under OSHA if it's not part of it. But by default, if you have an active mine site and you're doing some kind of construction on it, MSHA is going to try and inspect that. There a question came, or a statement more, a comment came in and said it's important to understand the MOU because newly hired inspectors may not. I 100% agree. I was talking to an MSHA supervisor at one point recently, and we were discussing a borrow pit, and I referenced and was talking about the MOU, and that individual didn't know what it was. And so I provided him a copy, and I think that, ended our discussion pretty quick, because our mind was pretty clearly a borrow pit per the MOU. But I mean, that was someone who had spent most of their career in the agency, and they weren't familiar with it, or maybe they just knew it by a different name. But nonetheless, yes, be aware of the MOU. And if you have questions on construction and what activities, whether you're doing a greenfield and making it a mine, or doing construction on an existing mine, that is gray area. You need to be prepared before you get into it, in my opinion, to have that discussion from an educated place with an inspector who might claim or attempt to claim jurisdiction over that. And that also has to be something that we consider when we're using contractors to complete that construction, right? So if we have different people on site, we need to make sure that they're trained appropriately for what they're doing, and they may qualify as a miner, they may not, depending on how long they're on site and what they're doing. But we need to, that's part of our analysis on jurisdiction, is making sure that our contractors are appropriately trained, because that can fall back on us as the production operator. So I hope that answered your question on the new construction. But if you want to talk about that further, just feel free to reach out, or if you guys ever have any questions about something going on and whether or not that's going to apply and how that's going to apply. So I said we would talk about this briefly, and we don't want to, we're covering a lot today, but agent liability is an area that people sometimes don't know about. It's a pretty powerful tool. MSHA can pursue it, action not against just the operating company, right? Not just your mine company, but also the individual agents. We don't, as I said before, we don't see this that often, but when we do, it's usually tied to something like an unwarrantable failure or a high negligence training order. It has to be something that ties back to more egregious negligence on the part of a manager, or what MSHA would call, in the unwarrantable failure world, aggravated conduct. Typically, they are going to then look at whoever the named manager was when the citation was issued, and maybe that's because they thought you had direct knowledge of the condition, or you saw it happen, or something of that line, and they're going to try and draw a straight line from the manager to the violation. This usually happens after serious accidents, or again, if there's an unwarrantable failure they feel is particularly egregious. In those cases, those managers want to be quite careful if there is an unwarrantable failure issued. If you're the named person in it, I'll talk about this when we're going through managing the investigation, but try and step back as much as possible. Hopefully you got multiple people trained, just because at that point, any statements made to MSHA are going to be of particular importance, and everything's going to be, we have to be of the mindset that anything that we say to MSHA could be used as an admission or against us. So be careful, and when we're in that area, the special investigators will come out. It won't be the same inspector. It will actually be a special investigator who shows up after the fact, and they will conduct their own investigation into agent management. They're going to look at the history of hazardous conditions. Were there similar conditions that you should have known about? Was this a common thing? Were you, as a manager, made aware of the condition and didn't take sufficient action to correct it or do so in a timely manner? Was it open and obvious? One area that comes up is, was someone not using fall protection and you were standing there watching the job take place? That's a pretty easy straight line there. But it's going to be based off of pretty much, the meat will be based on interviews with the target managers and with miners at the site. So be aware that that's going to happen. Special investigations can sometimes be a bit invasive or feel that way, because the MSHA investigator will immediately ask for a list of the miners who were on site at that time, or all the miners involved, or those involved, and they'll get their personal contact information. As a company, we have to provide that. And a lot of times special investigators will reach out and go to people's homes or call them on their cell phone. And, everyone needs to know at that point in time, your miner's rights still apply. You can participate in any interview you want. You can say no to that interview. That's entirely voluntary. You can tell the investigator that you want to do it at the office or at the mine. You don't want to do it at your house, or if you want to do it at your house, that's fine. But your miner's rights don't evaporate because someone's contacting you off the workplace. And if you're an agent of the company, and especially if you're the target of the investigation, my recommendation is that you have legal counsel there for an interview. And also be very careful when you're asked to sign anything, because as soon as you sign it, it's going to be used as a statement that is attributable, that MSHA will look at as a sworn statement. So be very careful if you're ever asked to sign anything. It has to be 100% correct. Every capital letter, every period, every new sentence, everything within those, it has to be 100% accurate before you should agree to sign it. And that's just a good habit for life in general, even outside of a special investigation. Additionally, the Mine Act gave MSHA the ability and the obligation to investigate and hold companies accountable for whistleblower provisions or discrimination against individual miners or even applicant miners who engage in a protected activity. This is another topic that we're going to have a webinar on as we get into later this year, but essentially protected activity means identifying hazards and reporting those to mine management, requesting or making an MSHA inspection or making a complaint to MSHA about conditions at the site, participating with the MSHA interview requests and sitting down with them, or refusing to engage in unsafe data. Those are some of the baseline, some of the very much the most protected of protected activities. And we're talking about, if someone engages in that, you cannot discipline them. You cannot dock their pay. You cannot put them on a different shift. You cannot, give them a worse piece of equipment. Those are all considered adverse actions, and MSHA is going to investigate it and will, hold the company accountable there. So MSHA will come out. Someone can make that request. MSHA has a new app that they put out. In that, there's some good materials for training. There's also a link that allows miners to make those kinds of complaints pretty easily if they have that app. So this is an area that we're seeing a lot of focus from MSHA on. They're really getting out there and kind of putting out information and talking to miners about their rights on this front and their ability to make complaints. So we are seeing an uptick in these. I will say these move very quickly. If there's a 105C investigation taking place, you need to be prepared to defend very fast. The best suggestion I can tell you is get counsel involved early. If you are subject or you receive a letter saying you're subject or some kind of communication to a 105C. That way we can, evaluate the case, start making a determination of how to defend it, or if it can be defended, right? We'll have those real discussions, with a client, but move quickly on them. They move quickly. MSHA will prioritize these over other special investigations. And if someone is asking for temporary reinstatement, that decision has to be made within 15 days of the complaint. So they move very quickly, and you should be aware of that. As we talked about, kind of some of those protected activities are making complaints. You have a couple different kinds of the complaints with MSHA. A formal written complaint saying we believe that there is a hazard here regarding X, Y, and Z is called an EO3. A verbal complaint or an EO4 is made just during an inspection or something, or during an interview. Both of them are going to result in MSHA coming out and investigating it or continuing a specific investigation into it. These are typically qualified as spot inspections or otherwise. If a complaint inspection is taking place on your mine, you should be getting a copy of the allegations, right? Same with if there's a 105C or a 110, you should be getting a written document which says this is what we're looking into. So keep on top of that. To the extent you're having a written hazard complaint or a hazard complaint investigation, that isn't necessarily an EO1, right? Go look at your entire mine site type of inspection. It can evolve into that. MSHA has a right to do that whenever they they want under the Mine Act, but it should be targeted. So, help yourself there, find out what specific areas the inspector needs to look at, and help them get to those areas, in an expeditious way, so that you aren't kind of parading around the entire mine. If that, you don't need to do that. Sometimes the inspectors want to look at different things. That's their right. We need to accommodate that, but to the extent possible, help them, inspector, complete the hazard complaint investigation and target those specific areas that are subject to it. That's just a good practice as you move forward and move through them. The last kind of part on the Mine Act side that we're going to talk about is judicial review. And that is, as we talked about, the Federal Mine Safety and Health Review Commission that was formed under the Act. It is a body which includes a commission to hear cases, and it's up to a 5-person commission. There are 4 commissioners approved and seated, and then also a kind of stable of administrative law judges. So if we do what we'll call formal contest, which is we get a penalty in the mail, and this is the easiest way to get through it, and we fill out that form and submit it and say we are contesting the citation, that's formal contest, right? We're going to get put into the pipeline in the docket at the Federal Mine Safety and Health Review Commission. We're going to have an ALJ assigned along with some representative from MSHA, whether that's a conference litigation representative or an attorney from the solicitor's office. And we will go through that kind of normal process of challenging the citation. It can be settled. If it doesn't settle, you can take it to a hearing. If you lose the hearing at the administrative law judge level, you can appeal it to the commission. Likewise, if MSHA loses and you win, MSHA can appeal it to the commission. The commission also hears or renders. It's just like it's an appellate court essentially at that point. And then, whichever side loses at the commission can appeal at that point to the federal circuit court system, whether in DC or wherever the mine or operation is located. So you have the ability to do that for anything MSHA issues. The timing changes based off of, whether or not you're contesting a 107A or 104B, something that doesn't carry a penalty every time, as opposed to you're challenging a 104A, 104D that has that penalty coming out. So, if you have questions about what to contest and at what time, we've done webinars on them, or, reach out. We're happy to talk through that. But you need to be aware, though, just that not every process is the same, but you have the ability to contest pretty much anything that MSHA writes, even if it's a 103K where they're cordoning off different areas based off a serious accident. You can contest the scope of that if it's burdensome. You just have to know how to do it and how to get before the commission. So an important step in what the Mine Act gave us, and also a way to exercise your rights there. Okay, so we'll talk a bit here, about managing inspections. I think some of the information that we have to consider here is things we already know, right? And that is particularly MSHA is going to be out to complete inspections. Unlike OSHA, MSHA will be, they're required to be, at every active surface mine in the nation at least twice a year. And that is an at least, right? They have to conduct 2 what they call EO1 enforcement inspections, general safety and health inspections at each surface mine. For underground, that's 4. So those are your baselines, right? If you're an intermediate operation, that is, maybe you're only operating here or there, MSHA is limited there down to 1 inspection a year, just a minimum of 1. But for the most part, for active mines, for active mines, it's 2s and 4s. And that means you're registered with MSHA as active. Now, MSHA the Mine Act gave them a very powerful tool, which is warrantless search authority. With OSHA, if they come up and they want to investigate, I'm not saying this is a good idea. You have to evaluate each instance separately, but you have the ability to say, go get a warrant. With MSHA, you can't do that. They have the ability to come on and inspect without a warrant. And that's part of what the Mine Act granted upon them. And that was because the Congress felt they need to be able to get there in a timely fashion in order to evaluate the safety and health of the mine. So beware of that. That's why MSHA can come out whenever they want and inspect us whenever they want. and they don't have to get a warrant, and they don't have to tell us when they're coming. They specifically can't tell us when they're coming, as we'll talk about with advance notice. So that is kind of setting the table there on, where we're at with MSHA's authority to be on site. So what can we do? Well, some of the best things we can do is prepare for MSHA to get there. Know your jurisdiction, as we talked about earlier. Know if there's any bounds of jurisdiction or questions of jurisdiction on your site. Know your history of enforcement. That's one of the best ways to know what MSHA might be looking at, especially if we just had a bad inspection where a lot of different citations were issued under the same thing, or the same standard, or the same kind of standard. Review your history, right? Review the MSHA website. You should be aware of that. MSHA considers that you are on constructive notice of anything they post, whether that's a safety initiative or an applicable saleogram or safety alert, because it's made available to public domain. Know your internal policies, because you can be held accountable for enforcing those or not, and know MSHA's policy. There are actually policy documents there. If you don't know them off the back of your hand, that's fine. Just know how to find them, and you can look through them. If you have questions about that, you can't find where those MSHA policies are, which affect enforcement or can affect them, let me know and I'll help you out. And then know how to check 30 CFR, right? A lot of times the inspectors are rattling off standard numbers that they think apply here. Know how to go back and verify it. You can do it on your phone now. You don't have to have the little flip book that the inspectors used to have. If you want one, you can do it, and you have a paperback with you. But you can download CFR to your phone, or you can just access 30 CFR online and check any standard. So find out, does a standard actually apply? Are they citing us for Part 48 when we're Part 46 mine? Know those kinds of distinctions so you can move ahead there. Okay, got some questions come in, and we'll take a look and see if we can get to these real quick. There's a question that says, I'm wondering how MSHA can get away with inspecting surface mines only once a year. The Mine Act doesn't state this, it states 2. I feel they pared back to 1 to achieve 100%. MSHA is required to inspect active surface mines twice a year. The question comes in its classification. If it's intermediate, it's not a status that, it's a status that has to be kind of verified by MSHA, meaning, it does not operate on a continuous basis. Maybe it operates for a couple weeks here and a couple weeks here, and, or maybe a month now, but it won't operate for 3 months after that. In that sense, because there is not continuous operation, MSHA limits the mandatory amount. But a surface operation that is active constantly is a minimum of twice a year. And that's what they base their inspection records on, and whether or not they're completing 100%. In terms of, one question is, how can we better understand the term strict liability? That is a good question. Strict liability is a term you may or may not have heard MSHA use at sometime in either the contest process or with an inspector saying it to you. And strict liability is a legal kind of term, a legal framework, the way something is issued. And ultimately, it means you can be held liable and responsible despite not being negligent. If you look at one of the best ways to kind of show it is, MSHA has a citation on there or on a citation, you have the negligence designations. One of them is no negligence. Now, we don't really see that selected that often, or at all, really. It's pretty rare, but that is because you do not necessarily have to be negligent to be held responsible. Strict liability is also how MSHA cites operators for non-compliance by contractors on site, because as the operator of that site, we are responsible for everything that occurs on it, and we are responsible for making sure that everything is in compliance with MSHA standards and regulations. So strict liability is a very strong term in a legal framework, which means we are responsible for everything that occurs on the site, which we maintain and we operate. that's a quick overview of it. And another question is, can MSHA make you open up inspection if your operation is closed due to storm, vacations, or other, but you are not officially closed? So to be closed for the purpose of avoiding inspection, you need to file a notice with MSHA, which you're actually obligated to do under a standard, which for surface operations is 56.1000. So if you were going to shut down for an extended period of time, you need to notify MSHA of that. That way they don't send inspectors out to you. If MSHA does send someone and the mine is closed, you're going to have to work that out with your individual inspector. And, hopefully though, you have filed that notice of closure beforehand. If it's due to a storm, because now it's not safe to operate, again, ideally you would have informed MSHA of that, but that's an instance where you got to talk to your inspector and let them know that we're not operating here because it's not operationable, and the inspector should respect that. They might want to go in and verify that's the case, and that you're not operating behind a closed gate, but the official closing is what kind of suspends their ability or their impetus to do an inspection. There's another question is, what is the best practice for when MSHA is on site, regarding who should escort MSHA inspectors, taking notes, et cetera. I promise that we are going to get to that here in the next few slides. So if there's still questions about that as we move through, let me know, and we'll get back on a specific topic, but we are going to cover those here in a few slides for us. So what else can we do before MSHA gets there? Review fatalgrams, review hazard alerts. Not only do these give us kind of a glimpse into what the inspectors are going to be told to focus on, but if there's a fatalogram that specifically applies to kind of a similar occurrence or the same equipment we have on our site, we need to review that, we need to train on it, we need to document that, because MSHA can use that as a way to increase not kind of negligence in any kind of situation where a citation might be issued. So, I'll just throw out there, if we have a suction dredge on site and there was just recently a fatal for a suction tread, and MSHA put out a fatalogram or a hazard alert with BEC practices, and we have a incident happen from the exact same conditions, and we didn't do anything to evaluate whether or not we were being safe after that alert went out, or make improvements in order to prevent a similar circumstance, MSHA can use that as a way to issue a citation with higher negligence, possibly aggravated conduct based off of that. So evaluate them all. If they apply, review them, train the team on them, do a toolbox talk or something like that, evaluate if you need to change your process, and document that so you get credit for that training. Know your record keeping requirements. Know the low hanging fruit that MSHA is going to look at every time they come on site. Workplace exams, have to have those for 1 year since the date they're made. Pre-shift inspections on mobile equipment. Task and site specific training. You got to make sure that you have those records. In particular, you got to have site specific training under Part 46 for every person that comes on site, regardless of their minor, right? Any person who comes on site has to receive it. And you got to figure out how you're going to document that. There's a number of ways to give site specific training, one of them being effective signage, but obviously you can't prove that anyone got that. So be aware of the site specific requirements. That's a pretty easy one. They're also going to look at your Part 50 reporting. So your injury and illness, are you filing your 7001? Are you filing them in a timely fashion? Are you filing your kind of addendum if your person isn't back to normal duty by the time you file that report? Those are low hanging fruit. They're going to ask for them every time they're on site. Prepackage them, and have multiple people know where they are so that you can provide them, and there's no question of whether or not they are going to be asked for. With pre-shift inspections, I will say MSHA does not give you a specific time frame you have to maintain those, not like workplace exams. Technically, you do not even have to create a pre-shift inspection report if there's no defects found on the piece of equipment that morning. If a defect is found, you have to record that. You have to maintain the report until the defect is created. All right. I think most times though, people are aware that MSHA comes out and you're going to stop an operator and say, did you do your pre-shift? And it's a much easier question if their person has a form that maybe it just gets tossed at the end of the day, even if everything's okay, that says, I did, here's my checklist of what I looked at. To the extent there is any kind of defect listed, whether it's on a pre-shift inspection, a workplace exam, or any other kind of submission, investigate it and correct it, right? And make record of corrective action. You're required to do that now on workplace exams, but it's also just a best practice on, if you have pre-shift, the defects are listed there. Either log it on the actual form and scan it in, or put it into a mechanic's notebook, but do pay attention to that. This is what the MSHA search bar looks like. If you're going to go in there, you want to look at your mine history, you can do it in there. You can search by your operator name or your controller name. You can search for contractors, or if you are a contractor, search for yourself through there, or by the mine name and mine ID. And the mine ID is that 7-digit number that MSHA awards to each location. Once you get there, you're going to have a drop or a screen that looks similar to this, where you can go through, and each one of the blue words listed in the column on the left-hand side, those are all hyperlinks. So you can go in there and look at your overview, which is going to be all your citations kind of aggregated per year and penalties, as well as your hours worked. You can look based off inspection. It will enumerate each inspection and what type it was, and then you click on there and you can get more into the enforcement issued if there was any. Accidents, violations is your enforcement history, and it keeps going. One thing I will say is the POV monitoring tool and your S&S calculator. We heard a lot about those back in the Joe Maine administration. They really got a lot of attention. We're talked about quite a bit. We didn't hear about them much during the Trump administration. When I have heard officials from MSHA speak recently, they are saying everyone needs to be monitoring their S&S calculator and their POV monitoring tool. POV, pattern of violations, is what it is. For the first time in quite a few years, we have mines on POV, or getting notices that they're going to be entering POV status soon. So stay on top of that kind of information so that you can be sure you know where your mine's at. You're not surprised when MSHA comes out and says something. So what happens when MSHA is getting there? We're preparing for before they come. First and foremost, identify who's going to accompany MSHA, who's going to exercise the company's 103F rights, all right? At each site, I think you should have multiple people trained so that if MSHA shows up when, you know, I say, Nick, I'm the only one trained, but now I'm on vacation or I'm out sick, who's going to accompany MSHA? Have multiple people trained on that. Have ideally at least one person or multiple people per shift so that they can fulfill that role. You need to outline specifically how these individuals are going to be contacted with MSHA arrive. That should be directly to them by their cell phone, most likely, right? We will talk about advance notice in a couple slides, but avoid that. Directly contact the person who's supposed to accompany MSHA. You should be prepared to take notes or have someone with you who's going to take notes, take photographs. If MSHA takes a photograph of something, you should take a photograph from that angle, and I'd say a different angle so we have a different perspective on it. Take notes, but understand that both these photos and the notes will likely become discoverable if you contest the citations later on or you're going to trial. So, you know, keep that in mind when you are putting the information in there. Try to avoid admissions of any kind. You know, leave it as very fact-specific information. You know, this is what happened. This is the area. This is the condition that MSHA is pointing out, and this is the standard that they're saying it allegedly violated. But document what MSHA documents, and then, like I said, take it from a different angle so that you have a different perspective, because that might help us very much when we're trying to evaluate the defenses for the citation. We talked about advance notice. It is a prohibited activity, and it means essentially announcing MSHA's on site or coming on site before they get there. It applies to MSHA inspectors. You probably heard them say, I can't tell you when I'm coming back. That's advance notice or something along those lines. but it also applies to people at the guard shack or people at the scale house or someone going on the radio and saying, hey, I need someone to come up here to accompany MSHA. They're on site. You know, if it's widely broadcast to multiple people throughout the mine or to a specific area, that is advance notice. You usually hear, you know, sometimes advance notice, it's coded words. You know, that's kind of the old way that it was looked at. You know, they radio down and say, oh, you know, are the parts here for conveyor 10? But there's only 6 conveyors on site, and there is none of them labeled as conveyor 10. You know, oh, well, that was a code that MSHA was coming. It's not usually like that in my experience when these come up. It's usually not intentional, and unfortunately it doesn't have to be. Case law has said it does not have to be intentional, but you just have to avoid giving advance notice. So directly contact people who are needed for the inspection. Do not broadcast it on a mine-wide radio. Do not broadcast it on a CB. Tailor that to the specific persons you need to inspect, to accompany the inspector, whether that is your operator's rep or an operator's rep and a miner's rep, if that is something that is present on your site. It doesn't mean MSHA can refuse to identify themselves. It doesn't mean they can refuse to have you accompany them. And it doesn't mean that they can drive past check-in locations to begin the inspection alone. None of that is protected by advance notice, right? You have a right as a company under 103F to have an operator's representative and a miner's rep. If that is something that exists at your site, accompany the inspector. And the miner's rep is really the right of the miners. We're crunching on time. I see a couple more questions coming in, so I'm going to keep going, and then we'll answer questions at the end right now. We try to stay pretty close to time for us, so I apologize, and if I hope you guys can stay along with us. If not, I understand, and you'll get a copy of the full recording when that comes out. Kind of goes to that. We want to have the same tools as MSHA, right? If we have a camera, notepad. If you see MSHA getting a tape measure out to measure something, you do the same. Be careful though, right? I always suggest that accompanying MSHA, you should be more of a listener than a talker, because your comments, if you are acting as the operator's representative, can serve to bind the company. If you sit there and you say, you know, oh, there's a guard missing. Oh yeah, I think that's been that way for 3 weeks. It's going to go in the notes that the operator's rep said it's been that way for 3 weeks. Usually the operator's rep is management. That's not always the case, but still in this role, you can be seen as such for the purpose of admissions. When an area that I wanted to touch on specifically, because we're seeing a lot more activity in it, is health sampling inspection. With health sampling, we've been seeing a lot more of it. We're probably going to get a new proposed silica rule from MSHA in the next couple months. Maybe it will be later this year, but right now their intention is to send it out next month and publish it. We'll see if that actually happens, but it is coming, right? That rule has been drafted by the agency, and we're going to see some version of it relatively soon and in the near future. But ramping up to that, we're seeing a lot more health inspections, especially on the metal, non-metal side and the surface operations. You know, you should know what your hazards are on site. You should know if you have, especially with silica exposure sources on your site. And we should be doing our own testing. We should be trying to get those under control before MSHA comes out. We shouldn't be relying on MSHA to be our sampling company, right? Our sampler. With that said, you should probably also have people on site who know how to run the equipment and run their own samples, because if MSHA shows up and wants to run health samples, you should be running a companion sample. And what that means is you put 2 pumps on the miner, and you know, you should be permitted to do this. If the inspector says you can't do it, or you're not allowed to run a sample, or it's hazardous to the miner, contact the supervisor, because they should permit you to do so. It's your right to run a companion sample. Also, running a companion sample is really the only effective way to challenge an overexposure citation. If MSHA gets an overexposure and issues the citation, and you have no data from that same time period, it's incredibly difficult to get that citation withdrawn or modified. You would have to prove that it was essentially there was error during the collection, meaning it was damaged or dropped or not calibrated or something. If you have a companion sample that was run at the same time and it's under and MSHA is over, you now have a leg to stand on. And hopefully you also have some historic data. We work with a lot of companies to run sampling when we're trying to evaluate what our risks are and where it is under privilege, so that we can try and protect those while we're evaluating, where we need to make improvements. And then later, once we're in a good spot, our clients, oftentimes just run them themselves to make sure that they're staying on top of it or are ready for it when MSHA comes in. But beware of this. That is your right. I would recommend you exercise it and have someone trained in order to exercise it. If, silica is an issue on your site, great. But you still got to consider if there's total dust issues, especially on the respirable side. That isn't even getting into kind of noise sampling and things like this. Just really, I wanted to focus on the respirable dust and crystalline silica, or quartz as MSHA refers to it sometimes, because those are areas that we're seeing a ramp up in attention to them. Inspections should have an opening conference, the body of the inspection, review of the citation, closing conference, and then a review of your company contest rights. If you're not getting those, ask for them. The opening conference is going to be a sit down where you have a discussion for 20 or 30 minutes, but you can ask MSHA to identify why they're on site. Are they doing a regular safety and health inspection? Is it a complaint inspection? If it's a complaint inspection, we need to, you want to see the list of complaints and review those with MSHA. The rest of it, I think is pretty much speaks for itself. If you have contractors on site and your contractors want to exercise their 103F, you need to talk about that beforehand, and again, have specific people to contact so that they can come out when MSHA is going to be inspecting their area. Sometimes contractor involvement is very limited, a couple people in one area, maybe they're drilling and blasting. Other times we have contractors running half the site. Those are nonetheless, we need to coordinate with our contractors beforehand on that. And if we're a contractor, we need to make our company or our client know that we're looking to be involved in that process throughout. We've talked about this, but under the Mine Act, you have the right to accompany MSHA during the inspection. That includes the miner's rep being there, if that applies to your site. And that's the opening conference, inspections, closing conference, anything that takes place that is part of the inspection. MSHA cannot require a mine operator or a miner's rep to allow them to walk through the operation alone. They can't say that they want to go this way and they'll meet up with you later. You are permitted and you should be on their hip throughout, not only so that you know what MSHA is doing, what they're looking at, but because it's a safety issue. You know your site, the inspector does not, right? So if they're trying to go down somewhere that's safe or they shouldn't be going a certain way, you need to instruct them that that is not the case, that they need to make sure they follow those kind of reasonable safety areas and reasonable safety practices. Does that mean they're going to subject themselves to a site-specific training? Probably not. Does that mean they're going to sign in and out of everything? Probably not. But when you're with them, make sure you're, informing them to not do unsafe things. If we are going to have MSHA show up, again, we need to contact somebody. And I think this is one of the questions that we just saw. How much time does safety have? Do the safety have to arrive once MSHA is on site? The big issue is there's no clear answer on that. There's no 30-minute, hour, 90-minute rule. It should be a reasonable amount of time. If it is a complaint inspection because someone called them and said there's unsafe conditions in the mine, that reasonable amount of time is going to be quite small. That's why we need to have multiple people on site trained. If it's a regular safety and health, that reasonable amount of time where they wait might be longer. Also, if we have all of our records in an area and we know they're good to go for training records, training plan, workplace exams, so on and so forth, I have suggested, and companies have done this before, where, offer that the inspector review those before, and give yourself a little more time because you're on your way from another plant. Sometimes inspectors are happy to do that. Other times they want to get out in the mine, and that's why we need to have multiple people trained. So there isn't a hard and fast deadline. There isn't a bright line rule that they have to wait X amount of time. It should be reasonable, but that could be 30 minutes, or it could be less than that if we're talking about a complaint investigation where they are being told that there is an ongoing imminent danger in the mine itself. So unfortunately, I can't give you a true answer on a specific amount of time there. A lot of it depends on the type of inspection. A lot of it depends on your relationship with MSHA. Do they know that you're coming and you're a safety guy and you have to be at all of them and you always are? And maybe they're more willing to wait for you in those circumstances and look at those training records in the interim. But there isn't a hard and fast line there. Be aware that we've talked about the mine operator reps can be considered agents. Those statements can be and probably will be recorded in MSHA's notes, and they can bind the company, especially if you're admitting to kind of the severity of a citation or how long something existed. Those will go directly to, help determine negligence designations by the inspector. That is especially true if we are talking about unwarrantable failure citations, or this could be the way we get to unwarrantable failures. So if you are accompanying MSHA, just be aware of that, right? Listen, ask questions. We don't want to offer up free information that may be damning, especially if we don't know specifically if that's correct or not. Maybe we're making an assumption. Don't make assumptions. We want to avoid those kinds of things. If you are going through, don't be afraid to raise kind of questions to the inspector during the inspection process, right? Whether it's, oh, I see a violation here, you can say, what is that a violation? Why is it? What standard? Ask questions, don't argue, don't turn it contentious. That usually doesn't work out in any operator's favor, but you can have that question where you're talking to them and asking for additional information for them to justify. If you think something does not apply, the best time to get rid of it is before it's written, right? So have that honest discussion with the inspector at that point in time. And if it seems like it's getting elevated and contentious, walk away. Just say, okay, well, we'll talk about this more later, or we'll consider that. But, you're allowed to ask citations. Don't be afraid to do that. As I said, the best times to get something withdrawn or before it's ever written. It's kind of like that old adage with a police officer giving you a speeding ticket. Well, I've already written it, so here it is. When MSHA gets citations, they, typically the inspector reviews what they're going to write with someone in the field office, usually the field office supervisor, especially if there's any questions about whether or not it is a citation. If it's, there's a guard off and there's a picture of an area like without a guard, that's pretty straightforward. They don't have to review that. But if it's any kind of question, typically they go back and they talk to their people. So you have a little bit of time. They're not issued on the spot. You guys all know that, right? They go back and they issue them at the end of the inspection, or the end of each day, or the end of each week if it's a multi-week inspection. So, talk about it and have that discussion before you actually receive the paper. Because once you receive the paper, there's limited things that you're going to get, right? They're not going to issue the paper and then go change it. That's what the informal contest process for. So, the closeout conference, it's a good time to discuss your questions or concerns, and make any objections that you want on the record. They should be included there. But, it's oftentimes too late to actually change it. If you need to talk to people and get some additional information and discuss that with the inspector and attempt to kind of get a citation not written, you need to try and do it before the closeout, because the closeout is going to be when you're presented with citations itself. So beware of that. And, if you're going to contest a citation, a lot of times when I see closeout notes, it just says, operator accepted citation, no questions asked. Operator agreed with citation, no questions asked. I don't think people are actually saying, oh yeah, I agree that that's a violation. So keep that in mind. If you're going to contest something or you disagree, say, I disagree with this issuance, we're going to contest it, and then that should be what's included in the notes. So just kind of small there. It's not going to move the needle too much, but it is a time when you can raise some questions or concerns without getting into it too much, because you have that informal contest process available, that 10-day afterwards, or the formal contest process. And we don't need to get into right now too much of the contest. We'll talk about that in other webinars, but those are the different areas where you can. The last slide I want to hit on today is just, if you're having trouble with an inspector, right? You think someone's being abusive in terms of how they're issuing citations, or they're being overly broad in their application. don't sit on that. Don't wait, right? You got to talk to them about it and bring it up to that individual inspector. If that's going nowhere, talk to their supervisor. Hopefully you all know and have made contact with your field office supervisor, right? Hopefully that's something that you have done so that they know you. And the first time they hear from you is not when you're challenging one of their inspectors and saying they're going off the deep end. If it is, so be it. But you all should try and at least have a phone call, if not an in-person meeting with your field office supervisor, so they know who you are. And when you call, you're not a blank face. They've met you before. They know who you are, at least have some recollection of it. If you are really having issues and you call your field office supervisor and you get no relief there, call the district. But I recommend you kind of work that chain of command, climb that ladder. Don't jump over everyone and ruffle feathers too much. But that is kind of an overview of soup to nuts, kind of that basic on inspection and a review of the Mine Act. I will review this and look through some citations, or I'm sorry, some questions about and get those here in a few minutes. But here's the upcoming webinars we have for the rest of the year. I hope that you will join me for those as well. If you are looking up there, you can see, next month is going to be a bit more on inspections, but on the serious side, we'll have our jurisdiction discussion later, as well as managing complaint investigations, more detail. So some of the topics we talked about today, we're going to dig into later in the year in a lot more detail. And if not, reach out to me and I'm happy to discuss it with you there. You can either register for all of these if you haven't already, or register for each one independently. That's up to you, but I welcome you to come back and join us again. As I mentioned, the MSHA Defense Reports, our blog, we will post topics on there. If there's rulemaking come out or cases that are of import, we'll put summaries up there. Additionally, though, our firm runs a similar blog on OSHA, employers, and then if you have California operations, Cal OSHA specific. And as we know, Cal OSHA not only governs OSHA sites, but also MSHA sites out there. So same thing, we have blogs or webinars for all these blogs as well. And if there's recordings that you're interested in, they're going to be up on those blogs, or you can register for those individual series as well. But with that, I will look and see what questions I haven't answered yet, and we'll get to those here in the next couple minutes. All right, it looks like there's just a couple questions that we didn't get, so I'll hit those right now. One question is on workplace exams or vehicle inspection records. If the operator mentions an item to fix for multiple days, when it gets fixed, do you need to mark every day the record that it was fixed, or just the final day? That's a good question. There is not a specific rule of thumb there. I would say as long as you address it, if you've looked into it and you're ordering parts, you might want to put that on there just so you can explain why something existed for multiple days. That's going to be largely dependent upon what the issue is and how serious it was for safety and health, right? So if we have an area that we barricaded off until we got parts, I would probably want to put that on one of the first times we looked at it, and then when it was fixed, because we got parts in, I would put that there when we removed it. But I think you need to evaluate with each instance, do you need to give more than just that final it's corrected? In the next question is, how can contractors know MSHA is on site if there's no opening conference that includes them? Would that fall under advance notice? No, it wouldn't fall under advance notice. It can, again, we don't want to broadcast it, but if MSHA is on site to do an investigation or a regular inspection, the contractor can be made aware of it, right? Because they are going to be subject to it, but you need to contact a particular person there. Maybe it's the safety coordinator for the contractor or the manager, someone that is going to accompany them. You can't just, broadcast or post it, in a bulletin board for all contractors, here it's coming. You need to directly contact those people, but it should not fall under advance notice if you're informing them so that they can exercise their 103F rights. It has to be, again, targeted to avoid advance notice, but you can inform a contractor that MSHA is on site and they're going to be inspecting their equipment or their area and operations. Yes. All right, that looks like the information that we have. We'll get this together, as I said, and sent out to each one of you by email, as well as posted online. There'll also be links in there to sign up for the rest of the webinars if you're interested, or our next one coming up next month. If anyone thinks of anything after the fact, feel free to give me a call or shoot me an email. I'm happy to discuss it. And thanks for joining me today. Bye.